Because sentencing, the first thing that's up, the state has the burden.
Judge, how are you going to handle the pre-sentence report that we made up?
Because of the nature of this case, it's going to be exhibit number 1. I normally don't make any exhibit, but I think in this case,
Fine with me.
Thanks,
So-
Judge.
somebody have a copy of it? It's not been marked up? And if you don't, I've got it in the file. I just got to find it. Which file it's in.
Judge, we have a clean copy.
General, the state having approved.
Yes, Your Honor, the state will call Sheriff Jeff Cassidy.
Raise your right hand, state your name, please.
Sheriff Jeff Cassidy.
Solemnly swear affirm testimony about to give the truth, all truth, and nothing but the truth.
Tell the court your name and where you're employed.
Jeff Cassidy, Sheriff.
We're really
of
live. I'm
County
sorry.
Sheriff's Office.
I got something in my eye like right before I turned it on.
Been with him a total of
Hi,
29 years.
Peter
My
G. Hi,
7th year as
Bushes.
sheriff.
I'm not going to talk through the whole
And
thing
so
though.
that,
Let me get it so that it's audio
you were
boosted.
2020 during the time of
One
this
second.
investigation. Is that
Yes,
right?
yes, ma'am.
And
Hi,
to take
Ringo.
back to
Happy
February
Steve.
2020, was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing child at first, and then once we found out that the last time the baby was saw was in December, we knew he was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover baby Evelyn.
Okay. How old were you told Evelyn was the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
It's approximately 18 days.
Yeah, from about February 18th till March 6th, I looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime?
Plus overtime.
Okay. So, let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up into North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, tried to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the virtual command center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. we utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So
Okay, can you hear me? Can you hear me now? No sound. I know. I'm sorry. So here's what just happened. I just plugged my camera in, and whenever I plugged my camera in, it deactivated the audio. So I am trying to figure out my life right now. So I apologize for that. I have to, yeah, still mute me on. Okay. Give me 1 second. Loud, awkward. Give me 1 second. Nope, I'm not going to be able to, I'm going to have to unplug my camera. Well, I was going to turn it on. Well, we'll just go back to no camera and womp, womp, womp. Okay. Because what's happening is it's feeding the audio through my camera instead of through the thing. So let me see if I start this back up, if it switches now that I unplugged that. I'm like new all over again. Hold on. I'm gonna have to stop the screen share and then restart it since I screwed it up. That's my bad. I was gonna stay here on camera so that I could freaking, yeah. Anyways, all right. Let me rewind that 10 seconds that we missed and tell me if you guys can hear it or not.
Evelyn, if the defendant had told the truth on day one.
Objection calls for speculation.
Sustained. Yeah, it needs to be framed. It's too wrong right now.
Can you kids hear it?
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
Absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could eat and still work, and they all pulled together during that time and just showed tremendous outpouring of support for our entire agency. And across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. They tried to send some home. They said, "No, I'm not going home. I'm going to work on this case until we find the baby."
Okay. No other questions? The
Thank
same
you.
questions Mr. Scott has.
I don't have any questions.
Thank you. Thank you.
State with call, take the next price. You're Matt Price, is that correct?
Yes, sir.
And what is your position at the sheriff's department?
I'm Lieutenant in Criminal Investigations.
All right. And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the sheriff's office. So I was the lead investigator.
All right. And you worked, the sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including the DBI, is that correct?
Yes, that's correct.
Okay. David Gratz at the time, also the two of you
Worked
worked extensively. That is
Yes.
correct. You familiar with the evidence that was collected in the case, the discovery of the body of victim Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so for sake of getting these exhibits in. I'm going to hand you the first photograph, ask you to show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evan was located.
And is that a true and accurate depiction
Yes.
of that scene?
Yeah.
Judge, would you make that exhibit number one to this hearing? Two, I'm sorry. And I don't know if it's helpful, but that was what the trial was introduced as exhibit number 15. I don't know if that's helpful or would create confusion or.
Just gonna be good for one in that sense.
Two. You recognize what's shown in the photographs just handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been moved off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would make that exhibit 3 to this hearing. Lieutenant Price, would you take a look at the photographs being handed to you and ask you to identify what's shown?
Yes, this is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we can make that exhibit 4 to this hearing. You recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evelyn was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
So the body's been removed from the trash.
Correct. The
bag.
body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evelyn's laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 this hearing.
So this today, Mama Bear, is on the other charges, which is like the abuse of a corpse and things like that. She was already sentenced to life with the possibility of parole
Do you recognize
for
what's shown in
the
photos?
murder charge itself.
Yes, I do.
But this is for all of the other charges, like the lying and
is
things like that
The
that
body
we're
of baby
looking at
Evelyn after
today.
she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil
It's like
wrapped around where her head
the
area
abuse
was.
of a corpse and things like that.
Judge, we would make that exhibit 6 to this hearing. Do you recognize the photo that's just been handed to you?
Yes, I do.
What's shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets, laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
No. Is that photo, one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we would move to make that exhibit 7 to this hearing. Lieutenant Fox, do you recognize what's shown in that photo?
Yes, I do.
What's that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the position of her head and how she was laying when the blanket was removed.
Judge, we move to make that exhibit 8 to this hearing. Finally, Lieutenant Price, can you do one more photo and asking you to identify that photograph, please?
Yes, I can. This is a picture of Evelyn, one of the last known pictures, so we know that she was alive.
Judge, we would make that exhibit number 9 to this hearing. Thank you, Lieutenant Price. You would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all the evidence.
Judge, if possible, I'd like to make an allocution.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
Judge,
I'm sorry. Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Ms. Boswell is a dangerous offender whose behavior indicates little or no regard for human life, that that she had no hesitation about committing a crime in which the risk of human life was high. This court should make those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in at trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole, and painful part of this, is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her new life. Megan chose living in a big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing is necessary to protect the public from further crimes, and provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death, and then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, that the results were fatal. Well, Judge, really, it does not get any more callous than what the defendant did in this case. She turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met, and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved as an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. So for that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on, and we would ask that they be run consecutive, Judge. Thank you.
Okay, before we go to the defense's hogwash statement that's getting ready to come, I'm going to go back to Evelyn or to Megan's statement so that those of you guys who didn't catch what she said can catch it, and I'll put it back down to normal speed because I think that might have been part of the problem. But I know that also the audio is not the best. So I do apologize for that. I do have it audio boosted on my end. This is a court TV live stream being a little bit on the lower side is the issue here. So it hasn't quite been 8 months, not 8 months. Life has just been busy. Hopefully, this is the first of many live streams to come. So if you are not currently subscribed, subscribe because I should be back. I should be back, hopefully. Let's cross our fingers. But life is calming down for the most part now, finally. And we are into the fall months, which lead to more home time and less sports and things like that right now. So here we go.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
If she would have had a fair trial and an impartial jury, then she would have been acquitted from the charges. And she did not hurt her baby. Like, what a load of crap. Still not sorry. Still not confessing to what she did. Still not any guilt or admission. Still nothing in regards to the fact that she did this. And if she didn't do this, she never reported her child missing. She never, well, I mean, you know what I mean, right? This is not. Mm, 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 mm. Evelyn was in her way, as the prosecutor said. She wanted to live a fun life and not have the responsibilities of being a mom, and she killed her child. And then she stuffed her in a garbage can and she put her in a shed that only she would have had access to, other than her family who did not real. Yeah, narcissistic. It's all about her. All about her and how wronged she was with her unfair trial. Like, people kill me. Absolutely kill me.
Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. So for that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on, and we would ask that they be run consecutive, Judge. Thank you.
Judge, to address this in somewhat the way Mr. Harper did, maybe in a backwards fashion. Ms. Boswell had no prior criminal history when the case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court with. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, and not run it consecutive. She'll be in jail until she's 69 years old. So the court then has to determine, is she, at that point, is she going to be a threat to society? Does society needs to be protected from 69-year-old Megan Boswell. The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentence is, short of the sentence is as necessary, so the court is supposed to do to achieve the purposes of the sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole, is what they want. And we have addressed that issue already, in a manner of speaking. I guess, practice law 25 years, I'm still in jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on these other counts, but I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges, obviously. They heard the guilt phase on those and convicted her of those. So, I think that is important to consider that. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merge together in this sentence. I would suggest, of course, that the murder counts merge together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. This is Supreme Court decided that 2014. It talks about cases just like this. Each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case that they had to merge. And that's what I think should happen here, is all those counts should merge. And I guess finally, I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for length of sentence. The defendant has a right to maintain their innocence, and to hold that against them and to somehow sentence them to more jail time because they don't come in here and say, I did it, that violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old, however that is structured.
Court will be in recess for 15 minutes.
That's what we just. Right. Exactly.
All the courtroom gibberish. I don't know if there was anybody saying anything important or not. Let's see. Yeah, let me see it. You hold the pencil there and I'll sharpen it. You want me to hold it? Hold on, guys. I gotta help her sharpen her pencil. Go ahead. You spin it. You got it? You gotta spin it hard. Is it too hard? We have like an old school, like actual classroom sharpener. Here. You got it? Try like that. Go ahead. Now try. Let me help you. Okay? You gotta hold the pencil still, baby. Hold it right there. You got it? How's it look? Is it sharpened? No. Okay. Okay. Yep. You gotta keep the pencil still, baby. You got it? Let me see. I think you're bending it. Let me see. Yeah, what defense attorney has Steele ever liked? Yeah, they all suck because they're always defending people who are just absolutely freaking horrible, right? Lakin Snelling. I don't think I have. Let me see. Is that one that we have seen in Discord? Oh, the Kentucky cheerleader. I did see that. Let me pull that over here for those of you guys who may not have seen it. It says cheerleader Lakin Snelling, whose baby was found dead in a trash bag, was dating a popular college athlete. Oh. Let's get all of the ads off the thing. Okay. University of Kentucky cheerleader whose dead newborn was found stuffed in the closet had been dating a former college basketballer, according to loved up photos that they shared online. One of the things that I have read in this one was that she was hoping for a girl, I heard, or whichever the opposite. I think it was a girl. And then the child that they found was a little boy. Anyways, let me keep reading this article. So it says her boo, Connor Jordan, was in front and center in a handful of posts on the 21-year-old cheerleader's social media accounts posted in the months before her recent arrest. However, it's not immediately clear if he was the father of the baby boy. Yeah, baby boy. So it was a girl that she was posting that she was hoping for. Hi, Red Rock. How are you? Hi, Black Country Bum. So they have not sentenced her yet. So we are still waiting for uh, the judge to come back. They're on a 15-minute recess. So it says it was not immediately clear if he was the father of baby boy. She is accused of wrapping in a towel, stashing in a garbage bag, and hiding her in the closet in her, or hiding in, I guess it should say him in her closet on her off-campus residence in Lexington. In one TikTok posted in June, Jordan, who was identified repeatedly as Snelling's followers, was pictured holding hands with the cheerleader and embracing her in a field. Another clip captured him kissing Snelling's cheek as the pair danced together. It isn't clear when they started dating. Jordan, who once played basketball for King University, appears to have deleted his own social media accounts in the wake of his girlfriend's arrest. It comes after it previously emerged that Snelling had been listed as a mom, or had listed being a mom as one of her life goals in a social media post, and just months before this weekly grisly discovery. I'm really curious if she actually killed this baby or if this baby was born stillbirth or something along those lines. Do we know for sure yet? In her last TikTok, which was posted on June 25th, she had included an emoji of a mother holding a baby under her list of goals, beside a wedding ring, house, and cash. She's like saying she wants to be a mom, but meanwhile, she has a baby in her closet. Meanwhile, she faced the court for the first time on Wednesday after she was charged with abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. She was arrested on August 31st after cops responded to a report of an unresponsive infant at the home. An autopsy has since deemed the baby's cause of death inconclusive. I understand the community's concern and sensitivity surrounding the death of the child. We are conducting a thorough and methodical death investigation to ensure all facts are carefully considered. She has not pled guilty on the charges. I mean, this really makes me wonder, if she was hoping for a baby and her goals were to get married and different things like that, you know, did he not want the same things, or was this baby born stillbirth? Was this baby did she not realize she was pregnant? I mean, I don't know. There's a lot of questions around this. But if you have a miscarriage, you don't just shove your baby in a garbage bag and put it in the closet. And so that's what kind of makes me think that, there's obviously nefarious intentions behind this, and she probably killed this child, unfortunately. But this is like not even this is not even something that's unheard of. Guys, this is why those baby boxes exist, to try to stop people from doing this to these innocent children. If you don't want your child, to take them to a safe haven baby box, to take them to the to the uh to the police, take them to a hospital, take this child anywhere. You can safe haven baby laws. You could drop this child off in most states up until they're 30 days old. In most states. Now there are a few states where it's like a week or 2 weeks that you can drop your child off, but there's no reason, if you have your child alive at any point, to shove them in a garbage bag or kill them in any way, shape, or form, and then just hide the fact that you were ever pregnant. And so then it makes me wonder if the boyfriend even knew she was pregnant, and did she maybe cheat on the boyfriend and had to hide the pregnancy and had to hide things because maybe they weren't at the time she conceived, maybe they weren't, sexually active with each other. And so maybe that's her motivation behind hiding this child because she didn't want to ruin this new relationship. Uh, it- I will just never understand, honestly, the thought process and the reasoning behind these parents, though, who kill their kids. Yes, Ringo, we were on a 15-minute recess. It's still up in the background, so as soon as they come back, we'll know. But we were just on a 15-minute recess. Oh, you were hoping for a girl with your second because you knew you wouldn't be able to get pregnant again, and you wanted a baby boy and a baby girl. You had a boy. You're so happy it didn't matter, right? Right. Right. These women. That's what I'm saying. Like, there's so many women that are just killing their kids. There's one not too far from me, just this past week, killed an adopted 9-year-old. It just makes no sense. Sounds like if she wasn't sure that the baby's yeah, that the baby was the boyfriend's, that could be the reasoning because she knew he'd ask for DNA. Maybe. Maybe. Yeah, your line of thinking too. I don't know. I don't know. I will never understand these parents. I mean, I just never will. And then they always think we're stupid. That's the other thing that gets me because they always think, let me shut off the screen share real quick. They always think that they're going to get one over on the police somehow. And then they try with this like, "Oh, my child's missing," or "My child was abducted," or whatever. And it never works. Yeah, you read about that case by me. It's horrific. Let me pull this one up. This one is another case of a failed system, honestly, um, because this is a child who was removed from her mom because her mom had issues and placed into a home that should have been protecting her. And then the people who were inside of that home killed her. And it's like it's Orrin and Orson West all over again. It's Ariel Sellers all over again. um, just the ongoing child abuse that had to have been occurring because this child was 9 years old and only 45 pounds. The ongoing systematic abuse that takes place in some of these homes where these kids are just straight up cash for kids. Just these people get custody of them just so that they can get their paychecks and then they treat them like complete and total garbage. That's the only reasoning that I can think of adopting a child and then not caring, not loving that child. Let me see. Pull this up. Oh, they're back. Court TV is back.
determining the appropriate sentence for these offenses, the court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made at sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, where with the range 1 being 2 to 4 years. The abuse of the corpse is a Class E felony, and failure to report death under suspicious, unusual, and unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
Her approximate age of death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
It was 13 years. 13 months old at death. It was 15 months old. They assumed when she was reported. When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state has, the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. The defendant had no hesitation about committing a crime when the risk to human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, was required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, the proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, when the court lays all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing, when the court weighs the enhancing factors and the mitigating factors, that's how I arrive at or not a verdict, but a sentence. I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity to those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion counts 4 and 5, that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's been giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says, in that case, that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge, counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, that urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And then, of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, when we would have all the false report counts to rely on false criminal history. Obviously, since this was standard, more duplicitous, that doesn't exist anymore, so we're not relying on that.
Quick objection. The court also relies on enhancer number 4 from the same statute, 4035-115, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But as pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the big main case is the Wilkerson case, 905 Southwest 2nd. (933) Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 4035-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was if that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Evelyn Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child, the court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then, would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage
Loving everything to this. Go, Judge, go.
was written
This is awesome.
to describe this case.
Lock her up.
Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, Sherry, I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing hearing will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, but I'll wait Ms. Boswell's appearance at that.
Well, what I prefer her to do is appear by Zoom.
That's
If-
fine.
If she can, but if not, yes, we can.
Okay.
All right. All right, that's all.
You know, in a world full of judges that are constantly letting us down and being soft on criminals, I am so thankful that this judge, he just threw everything at her. So she was already getting up until age 69 because of the murder charge. That was guaranteed. 69 years old is the term that she was going to service there. He just did these additional 33 years consecutive to that, which means that, and he said that only 8 years of that would be able to get parole. So 69 plus 25 guaranteed. 69 plus 25 that she cannot get parole in. She would be at least 94 years old. Lily just turned on the fan, so I apologize if it gets windy. So she would be at least 94 years old before she starts to service the 8 years that she could potentially get without parole, or that she could potentially get parole on. So at least 94 years before that last 8 years of her sentence. She'd be 102 years old before she could ever possibly, 94 before she could possibly get out on parole. But yeah, he just threw the whole book at her. Like, I am so happy. I am so glad she got her new life. She got her life without her burden, Evelyn, and now she doesn't even have to think about anything. She don't think about what she got to wear the next day. She don't have to think about where she's going to sleep at night. She won't have to think about what she's going to eat. Everything will be all planned out for you, Megan. Everything will be all planned out, and you won't have to worry about a thing. You won't have to worry your pretty little heart out over anything that's going to happen on the day-to-day basis, except for, what type of girlfriend you're going to get in prison. I am so glad. That is awesome. There are so many of these criminals that I wish that would get similar sentences to what this judge just did to her. We don't have to ever talk about this again. I'm sure she will file an appeal, especially since she is convinced that she was wrongly accused and things of that nature. And I'm sure that we'll have to go through the appeal process. But until then, you are done. Yeah, you hope it's a living hell, right? She got the simple life. That's exactly it, Ringo. She got the simple life that she has always wanted. She will have to clean. She won't be living in all that trash and things like that that she was used to. She will have to keep her area nice and clean, and she'll just have a simple, simple life. Plenty of time to think about what she did. You know what though, Granny Annie? I don't even think people like her do think about what they did. I know we always hope that they're like sitting there wallowing in their guilt and that they're getting eaten away by the ideas of what they did and their daughter's eyes like looking up at her as she stuffled out her last breath. But I don't think that these monsters see that. I don't think that they literally have even 1 second of a thought of anything outside of outside of themselves. I really think that they are just very primal creatures, and they are so selfish in themselves and so consumed with their own thoughts and their own like primal instincts to just get what's best for them and to survive how they need to survive, to eat, sleep, drink, make their lives the most comfortable. Those primal urges. Um, I think that they are just so consumed with that they don't even think about it. She will have no remorse throughout all of her time served in prison. And all she will do is the same thing that we see all these other criminals that think like her. She will go to jail and she will try to find her own network there and try to thrive in that prison. And that makes me sick. But you think about cases like Letitia Stout, for example. They just make a new life in prison, manipulating the prison guards and manipulating the other prisoners and trying to become top prisoner and things like that. And it's gross because they really don't think or care about anything other than their own primal instincts. I don't even think that she's capable of remorse. I really don't. I mean, even whenever he was talking about baby Evelyn, I was watching her eyes like real close. I had her zoomed up on the big screen. I was watching her eyes real close, and she was like looking down and closing her eyes at different times whenever he was talking about how she stuffed her into the trash can and how she did all of these things. And I think that her looking down, her closing her eyes, it had nothing to do with her thinking like, I can't believe I did that to Evelyn. No, I think it was more like, I can't believe that child once again is ruining my life because what I did to her, not what she did to her, but what that child made her do to her type of thing. That's the type of thoughts I imagine, that she is like blaming Evelyn still for the charges. I guarantee it. I guarantee it. Not the fact that she committed the crimes, but the fact that the mitigating circumstances is the fact that this baby could not survive on her own, relied on her mommy for care, trusted her mommy, loved her mommy. All of those things were the stuff that the judge said. And she still, I think, in my opinion, was sitting there feeling that bitterness towards the baby, towards Evelyn. So, you know what? Justice is served and she will rot in prison and someday she will probably rot in hell. But I don't think that she'll ever think about this or wallow in her misery or replay these moments in her mind. I don't think any of that will ever happen unless some type of divine intervention occurs. Yeah, the images of her in the aluminum foil, right? It's just disturbing. It's just disturbing. So, all right, guys, I am going to go ahead and close up shop now. I have to head over to my mom's. For those of you guys who don't know, part of my busy life lately, we have been remodeling a home that my mom bought. She got it for a really decent price, and it's just been a constant remodel project. And so I have to share some pictures with you guys, but we are hopefully going to be finished with the upstairs of this house remodel this weekend, and that'll certainly free up a lot more time in my life as well. We've spent the last 5 6 weeks over there, pretty much daily in between other stuff. And then my cousin also bought a restaurant, and so we were helping him remodel. So we were remodeling the restaurant on the weekends and doing my mom's throughout the week. And so it's just been life has just been nuts. But I look forward to seeing you guys soon again, more often, more frequently. I'm not going to say when, because every single time that I try to say when I'm going to go live again next, stuff goes crazy. So we're not going to talk about it. I do have an MRI coming up, hopefully sometime soon, but all of the things, because I actually got injured throughout all of the course of my life too, and got some back and neck issues going on. So hopefully that doesn't lead to like surgery or anything like that. I don't know what's going to happen, but yeah, absolutely. I I am glad. I am glad that I was able to come on and do this. I wasn't sure if I was going to make it or not, so I didn't post it until last minute. But I definitely want to follow the cases, especially that we have been covering in the past. I want to follow them through all the way through. So yeah, doing all the things. Miss you guys too. But I will talk to you all. Yes, justice for baby Evelyn all day long. I'm so glad that this is done and that she's just locked up now. Yeah, that's it, Ramblin' Room. If we want to come for a working visit, that's it. Everybody's like, "Oh, are you heading here next?" Like, I hope not. So, all right, I will talk to you all later. I hope you all have a good evening. Love you all. Bye.